Hi, it's Nicola from Morecambe Bay Wills, and I wanted to just give you a little bit of information about a new draft wills bill. For those of you who don't know, the last Wills Act was made in 1837, so 188 years ago, and obviously it's quite old legislation now. So last Friday, the Law Commission published a draft bill for government to consider, so it isn't law yet, but it includes some wide-ranging changes, which I think will probably bring wills into the 21st century, even though they didn't really make the 20th century. So huge range of changes, some of which will come in, some of which may not get through the government process, but it's important that we at Morecambe Bay Wills understand them and plan and prepare for when these changes happen. So over a few short videos, I'm going to explain a little bit more about the changes, and then you know a little bit more about what's maybe going to come. And one of those changes is the change of age. So at the moment you have to be 18 to make a will in England and Wales. It's much lower in Scotland, and some countries don't have an age limit at all. The proposal is going to be 16, which aligns with many other things that you can do at the age of 16, with, I think, the potential for people even younger than that to make a will if the court decides that it's in their interest. So perhaps, maybe somebody who's very ill, maybe somebody who has an estranged parent, and they want to make sure that if anything does happen to them, that whatever they have goes to whom they want. And for example, people like Luke Littler, some of the Premier League footballers, again, they're under the age of 18, so that would be really useful for them. One of those provisions in that act was that if you got married, your will was revoked. In Victorian times, that might have been useful for perhaps a lady who married a gentleman who had many more assets than her, and so therefore it gave her some protection that if he were to die, then she would inherit some of his estate. And obviously in modern times, that's far less relevant. One of the things that's a little bit more concerning is the rise of something called predatory marriages, where someone perhaps marries someone just because they know they've got a large estate, and they would inherit from that estate if their new spouse dies and their will had been revoked. So interesting to see if those changes do come in, and for now, no changes because the laws haven't yet been updated. So it's really important to understand that if you do have a will, it is revoked if you do get married. In that act, there's absolutely no provision for today's modern technology and the modern world we live in. So one of the exciting changes that's proposed is the introduction of electronic wills. I think there's a lot of work to be done on that, particularly in terms of safeguarding. But for example, some of you may remember Max George recently, the singer of The Wanted, wanted to make a will, and he made one on his mobile phone before he went down to surgery. And of course, that wasn't valid. But there's no reason in this day and age why, with good safeguarding of ID technology and digital signatures, for example, that we can't consider that type of technology. I think we all realise that there are many hurdles to get over before that is actually something that's actually in practice. But in law, we do see electronic signatures in other areas of law. So, there's no reason why this couldn't be considered. But we see it as a really exciting change, and something that some of our clients may be really may find really, really useful in the future. Anyway, not here yet, but look forward to something like that coming in. Now, a short series on the potential changes that might come up in the new Wills Act, which was published last Friday. That's the draft Wills Bill. And obviously that isn't law, but if it does become law over the next year or so, then it will replace the 1837 Wills Act, which we all have to follow at the moment. And there is a very specific section in that which really details how the formalities of a will can make sure that it is valid, and that includes signing in the presence of two witnesses and them signing at the same time. And we see sometimes cases where, you know, people didn't get round to signing, or just by accident signed it incorrectly. There was a famous case where a husband and wife signed each other's wills inadvertently, and then of course when one died, then it was deemed that that will wasn't valid. And the judges at the moment don't have the power to vary that. It's either signed correctly or it isn't. And so in that case, then both wills were deemed to be invalid. The proposal is that judges will have far more discretion of whether or not to just establish that the will that is presented, whether or not it's executed properly, is actually what the person intended, and therefore to be able to vary those provisions and those rules. Anyway, interesting times. Hope to see them soon. Bye.